Now, about the resignation of the two UK judges who have been serving on the Court of Final Appeal of the Hong Kong Special Administrative Region since 2017 and 2021, respectively, I, together with the Chief Justice of the Court of Final Appeal, have expressed regret on their resignations, because non-permanent judges from common law jurisdictions are playing a very valuable and useful role to Hong Kong, and is a vote of confidence in the judicial independence of Hong Kong. So it is something to be regretted that they have decided that they have to leave. But what I find very disturbing, and I could not accept, is the association of the judges' resignations with either the implementation of the national security law or the practice of individual rights and freedoms in Hong Kong. The rule of law has remained as robust as ever in the past 25 years after the reunification. The national security law is a very essential and legitimate piece of legislation to restore law and order in Hong Kong after what we have gone through in the latter part of 2019, with a spate of unprecedented riots all over the territory. And every country has a national security law. Our national security law is much narrower in scope and is very clear on the 4 types of offenses. And our national security law is perhaps one of the few worldwide that allowed non-Chinese national judges to adjudicate, right? In most jurisdictions, if you want to sit on a case concerning that country's national security, I gather the basic requirement is the judge has to be a national of that country. But in our case, because of the provisions in the basic law, and we do have a lot of non-Chinese national judges sitting not only in the Court of Final Appeal, but at various levels of the judiciary. So the NSL, the Hong Kong National Security Law, does not prohibit overseas judges or expatriate judges to adjudicate on cases concerning the national security law. So now to use that excuse as a reason of no longer sending out judges, serving judges to sit on the Court of Final Appeal is totally untenable. Yeah. And there is also a misperception that judges, overseas judges sitting on the Court of Final Appeal is a legitimate endorsement of the government. That is never the case. I would suggest you can go back to all the documents we issue about the appointment of CFA judges. They are much valued in helping Hong Kong to safeguard judicial independence. They are not lending us any legitimacy. Us means the administration. So to suggest on this occasion that they could no longer sit on the Court of Final Appeal because to do so would appear to endorse the administration is a very fallacious argument. And I can only draw the conclusion that there must be quite a lot of politics behind it. And in fact, in the last 15, 16 hours, all the commentators in Hong Kong, including very distinguished senior counsels, have all suspected that this is a sort of political manipulation. I do not want to repeat what has happened in London on the 30th of March, that is yesterday, with the UK parliamentarians debating on this issue, with the Prime Minister, Foreign Secretary, Justice Secretary, Lord Chancellor, all speaking with the same wavelength. And then the two judges, two very fine and distinguished judges, tendering their resignations. But having said all this, I remain very confident, because your question is whether I was worried. I was not worried. I remain very confident that we still have very fine judges in the judiciary, both local and overseas, serving at the various levels of the judiciary. And each one of them will serve with devotion in accordance with the judicial oath that they have taken. So Hong Kong will continue to benefit significantly from an independent judiciary who will adjudicate without fear or favor. And I'm sure that we will continue to see fine judges being appointed at the various levels of the judiciary. Thank you.